So today we are here to get ready for the hearing, and you have waited quite a long time to get to this point. And my job today is to help you be best prepared for the hearing. One of the things that we need to do today is talk about the procedure, what to wear, what the rules in testifying are. And we're even going to go through the questions, and I'm going to go through what some of the typical questions are, and I'm going to help you formulate the answers. Now, I know that you have lots of questions and you have lots of anxiety about the hearing and what to expect, and so that's the purpose of meeting here today. So you may wonder why I do part of this in video and part of this in person. I've spent a number of years in this practice area, and the basic information I'm giving you give to all my Social Security clients. And so what I'm going to do is I'm going to speak to you through this video today for about 20 minutes, 25 minutes. Going to go through some of those basics, and we're going to review a couple of things that are important to you. And then after this video portion finishes up, then I'm going to come in and we're going to work specifically on your case and the issues that you have with disability and why you can't work 8 hours a day, 5 days a week on a sustained basis, so that we will go forward to the hearing the best possible way. I know you're nervous, and I know that you're wondering, when am I going to get a decision? Elizabeth, I've been waiting months and months and months. And unfortunately, it's one of those things of hurry up and wait. So we do our hearing prep today, and then we go to the hearing. And then it's going to be hurry up and wait some more for the decision. We're not going to find out that day. We get notice in writing. It could take anywhere from a couple of days to a couple of weeks to a couple of months. I can't change the process. I just won't slow the process down for you. So please know going into the hearing that your file is complete. We have done the work that's needed. We have you here today prepared. And so once we have that hearing, it goes to the judge. I don't get hot and bothered until we're about 60 days out. And it's 60 days after your hearing, if I haven't received a decision from the judge, then I will make inquiries. But we also have to be careful about that, because if we stir the pot a little bit too much, I don't want there to be a negative connotation with the name. So again, it's going to be hurry up and wait, and we're not going to get a decision that day. And I know that's disappointing to you. When you came in today, my staff had provided you with a sheet. It's kind of like this, and it has on the top your name, the hearing date, the hearing time, the arrival time. And so the hearing time is going to be the time of your hearing that you need to be at hearing at. And I'll tell you this, if you're scheduled for 9 o'clock, it may go at 9 o'clock. But it may go 9:15, it may go 9:30. We don't know what's happened the case before yours. And so we have to exercise a little patience. And I know you've exercised great patience to get here today. The other thing with that is arrival time. I have you meet me there 15 minutes ahead of time. Your Social Security papers are going to say you can be there a half hour early or an hour early. That's to review the file. You don't need to review the file, because I've already reviewed the file multiple times, as is my staff, and we're ready. That's why you're meeting with me today, to go through the medical records, to make sure we have the medical evidence, to go through the questions. So despite Social Security saying be there a half hour early or be there an hour early, just follow the time that I'm going to list on the arrival time and be there. Now, the other thing is, you may not see me because I may be in a hearing already with a different client with the same judge, but know that they're not going to have you start your hearing without me, but I'll be there. Now, the other important part on the paper is notice that it has the address. So if you use a GPS, you can put that in to get the address, and it has the phone number for the office as well. So if you get lost or you get behind a school bus, you'll have that phone number. I also have the written directions to get you to that hearing office, and also a map of the area. One of the important things to know is that although the Social Security office is in a public building, once you cross over into the Social Security office itself, you are on federal property. So you need to leave your gun, your knife, your mace, your illegal drugs, and your alcohol in the car. You kind of laugh and say, oh, Elizabeth, I know better than that. I've had all of those things happen, and then people get arrested and they get themselves in trouble. So, just be sure that you leave those things in the car that day. What you're going to do is you're going to go into the office, you're going to go through security. You have to have photo ID, and it needs to be valid. If it's expired, you're not going to get in. That's the law. Can't change it. Social Security on everything that they've told you has said you need valid photo ID. So if you don't have it now, you need to go to the Driver License Bureau and either get your updated driver's license or get your ID card. I can't do anything about that. The security guard is not going to let you in. You have to have photo ID. I would suggest for all my female clients that if you're going to bring a purse, be sure and just bring a small purse. Don't bring a big purse. Because if we tell the judge that you can't lift more than 5 pounds and you're carrying a 15-pound bag, that's not going to work out. So one of the other things that we went over with you is your medication sheet. One of the things that Social Security will ask in the hearing notice is that you bring all of your medications. Many years ago, I stopped having clients do that because our hearing is going to be a half hour to 45 minutes long. I can't spend the time during your hearing going through your medications bottle by bottle, trying to pronounce, how do you pronounce those, and spelling those and what the dosage is. So what we've done in all of our cases, and you filled this out before for me, but we're going to do a final version of that, and we're going to give that to the judge today after we meet so that he has this ahead of time. So he'll know the medication, he'll know the dosage, he'll know if there's side effects from the medications. So don't bring your medications that day because we're going to take care of that today and submit that to the judge. Now, that being said, if you use a walker, if you use a cane and it's prescribed, by all means, even if you're not using it right now, I want you to bring those things with you. One of the things that we didn't talk about is what to wear, and that's a common question. I used to tell people that they should wear what they wear at church, and then you see what people wear at church these days, and that's not very good in some cases. So no shorts, no flip-flops. You can wear jeans, but don't wear jeans with holes. Make sure your clothes are clean. Best bet is to wear a long sleeve shirt, nothing with writing on it. I don't want the judge to ask you, did you go to the Steelers game? Or if you have a Hello Kitty t-shirt or something like that on. It's not appropriate. It's a court proceeding. We want to show some level of respect for the court. The other thing is, although the law isn't that you can't have tattoos and piercings, my job is to best prepare you. And I know these judges, and they don't necessarily appreciate lots of tattoos and lots of piercings. It's a distraction more than anything. And so let's do our best to cover those up, take them out. I'm not talking about earrings in your ears, but may not be a problem for you. But I'm just mentioning it because many of these Social Security judges have somewhat of a military background. I am all for the Constitution and the amendments and free speech and all of that. I'm just telling you, based on my experience, I want the case to be about you and why you can't work. I don't want it to be about the one that had the Budweiser t-shirt on or the one that had the crazy tarantula tattoo on your hand, okay? So let's try to keep those things to a minimum. What we're going to be talking to the judge about when we go into the hearing is why you can't work 8 hours a day, 5 days a week on a sustained basis. It's not that you have depression and anxiety and you have a bad back, because guess what? That's 80% of the workforce on a given day. And I'm not making light of that, it's just that the limitations that you have, and we're going to go into that when I come in and talk to you, it's going to be those functional limitations that keep you from working on a sustained basis. A couple other things in terms of procedure and getting ready before we go in to the Social Security hearing. When you're there and you're waiting for the hearing, there could be one judge holding hearings that day. There may be 5 judges holding hearings that day. So you don't want to be talking about your case, because I don't know somebody from Social Security, but also it's really not, it'd be kind of like talking about your medical problems in the doctor's office in the waiting room. Probably don't want to do that. Also, want you to turn off your cell phone, and better yet, just leave it in the car. I had one time where I'm in the middle of a hearing and a cell phone went off. And again, I don't want to be remembered as the one who had the client whose cell phone went off. It's a level of respect. It's also a disruption and an interruption. So what will happen is we're in the waiting room. We're waiting to be called. A nice person will come out. They're the hearing assistant. They're the person who tape records the proceedings for the court. And they'll just ask us a little background information. They make sure that the judge is going to be ready for us. So one of the things when we talk about the hearing officer tape records the proceeding. So it's important that when you testify that you answer out loud. You say yes, you say no. If you say it hurts here. Well, no, it doesn't hurt here. It hurts at my right elbow. You can't say you can't say nuh-uh, you can't do a shake of the head like all of you are doing to me right now. And the other thing is, don't say yeah. We're in court. Yes, no, I don't know. We need to be sure, because it's not videotaped. It's not like video like this that we could get a nod of the head. It's audio recorded. When it's our opportunity to try our case in front of the judge, it is a closed proceeding. So it's not open to the public. It's not like Law and Order that you've seen where there's courtroom scenes and there's a jury and there's a gallery. It's closed. There's no attorney for Social Security. There's no witnesses typically. It's going to be you, it's going to be me, it's going to be the judge, the hearing assistant, and the vocational expert. There's going to be a rare case where we may use a witness, and for those of you who have witnesses or want to have witnesses, we're going to talk about that today. But when we go into the room, it's a small room. The judge may or may not be wearing a robe. There'll be a big table in front of the judge's bench, and around it will sit the hearing officer, me, you, and the vocational expert. You're going to see a bunch of computer screens, including my computer, I will have your medication list for you so you don't have to remember your medications. The judge is probably going to have 2 or 3 screens around him, and sometimes you'll think, well, how is he even hearing my case because he's looking at these screens? One screen's going to have your medical records on it. One screen's going to have his notes. One screen's going to have the law. So he may be looking. I may be looking. You're going to have the hearing officer who's going to be tape recording but taking notes, and you're going to have the vocational expert as well who's going to be looking at a computer. But know that everybody's listening, but we're all making sure that we're prepared and we're moving your case forward. I do want to make a quick note here, and we're going to talk a little bit more about the vocational expert in a couple minutes, but I'm noticing in some of my hearings that the vocational expert is not coming into the hearing. They're being patched in by telephone or by video. And that's becoming more and more common. And please know that I know who the vocational expert is ahead of time. I have their credentials, and I also know basically of the ones that I'm familiar with, what type of testimony they're going to offer. I think it's a cost-saving move on Social Security part, not really sure, but I haven't had any difficulties with it. But I just did want to mention it because if you don't see the vocational expert there and they're by phone, then I'm seeing that more and more. So once we get into the room and the judge introduces who the players are, he will do some preliminary work. Now, although it's an informal proceeding, again, there's no lawyer for Social Security at this point, you will be sworn in, as will the vocational expert, and asked to give testimony under oath. Depending on who the judge is, it's going to depend on how the hearing goes from there. Some of the judges do all of the questioning. Some of the judges have me do all of the questioning. Sometimes it's a combination of the two things. And we're going to talk about 3 rules right now in testifying. So I want you to take your piece of paper. I want you to turn it over. Don't want you to use the notebook that you brought with you. I want you to go ahead and write on the back of this. So 3 rules in testifying. And if you don't remember anything else, but you remember these 3 rules, then you're going to do great. So rule number 1, and I want you to write this down, is you need to tell the truth. And you're kind of like, yeah, Elizabeth, and tell the truth. Here's what happens. Whatever you've been telling your doctors, the judge has been reading all of those notes, so you better be telling the judge what you've told the doctors. Rule number 2, you need to tell it like it is. And by that I mean, if you go in and you tell the judge that everything's fine, you're not going to win. On the other hand, if you show up in a wheelchair with a neck brace on and an eye patch on, unless you've had some horrific accident, you're exaggerating, you're not going to win. You have to put yourself in the position, and it's very difficult because you don't go around telling people your problems, and you've never met these people and you're never going to see them again. And you have to go in and explain what your life is like now. And your life now is not what your life once was before you had your disability. But my job is to help you be able to do that when we go to the hearing. So that's why it's really important that you tell it like it is. And we're going to go through some examples of that when we meet individually. 3rd rule, and really important rule, especially for my talkers out there. You need to listen to the question and answer just the question. So if the judge asks you, How many times in a week do you drive? He's looking for a number. Do you drive 5 times a week? You don't say, well, a few. What does that mean? If the judge asks you if you have a drug or alcohol problem, the answer is yes or the answer is no, and then let him ask the next question, or let me ask the next question. Again, Social Security is not about the impairment or your medical condition. Social Security is about the functional limitations, about walking, lifting, carrying. It's about concentration. It's about memory. It's about what happens to you when you're in the workplace and why you can't work. So the questions that the judge asks and the questions that I ask really go to that functionality. We need to talk a little bit about the vocational expert. The vocational expert is a jobs expert, not an employee of the Social Security Administration, but paid by the Social Security Administration. And their job is to tell the court, based on a hypothetical, whether there's jobs out there that such a hypothetical person could do on a sustained basis. So, for instance, if you are of a certain age, education, work experience, call it skilled or unskilled, and you have certain restrictions in lifting, walking, carrying, or you have certain restrictions in terms of your mental health, are there jobs out there that you could do on a sustained basis? And how it kind of works is, judge will ask a hypothetical, and typically the rule of thumb is within 2 or 3 questions, if the judge gets an answer from the vocational expert of no jobs, I know in my years of experience to shut up, grab your hand, and get out of there, because that means we're going to win. That happens in 99.9% of the cases. There are some of those cases where that's not the case. And so I need to then ask very specific questions of the vocational expert, which means I've had to review your records to make sure that I know all your functional limitations and add that to the hypothetical so that I can get a response from the vocational expert that's favorable to us. That being said, and this is kind of weird, is with that, the testimony of the vocational expert is not necessarily binding on the judge. So what we have to do, you may say, well, the vocational expert, Elizabeth, said no job, so hey, we won. Well, the question is, do we have the evidence to support that? And that's my job, is to make sure that the questions asked, there's evidence to support that limitation. One of the other things I want to talk to you about, and I talked about this briefly in the beginning, is that we're not going to get a decision that day. But some of you are probably saying, okay, Elizabeth, what's going to happen when we get the decision? And I'm just going to talk about this briefly, because I like to do things in steps. You know that, one step at a time. But if you win, then your file goes to a different office and goes to a payment office. Takes some time for that to be processed. How I get paid, and I'm just reiterating the terms of the fee agreement, I get paid out of your back benefit award, 25% of the past due benefits up to $6,000, whichever is less. Social Security withholds that and pays that directly to my office. However, expenses, or the cost, are your responsibility. And we ask, and I will let you know what that is, we ask that you reimburse us that when you get your back benefit award. And that's really important because that helps me fund the other disabled cases that I'm working on. The other thing to know is if you get an unfavorable decision, we will then talk about what your options are at that point. Whether we are going to file an appeal to the Appeals Council, file a new claim, have another attorney review it. And if you receive an unfavorable decision, just remember from our fee agreement, you don't owe me anything. It's no cost to you at all. The most important thing to do is when you obtain the decision in the mail, I need you to schedule a phone conference with me. If you don't call and schedule a phone conference with me, then I'm not going to know that you want to talk to me. So, you have my email, you have my phone number, you have the text-to number, lots of ways to get a hold of us. We'll get you scheduled within a couple of days to do that. Now, the other thing I want to briefly talk to you about is what the first question is going to be. And the first question, and I'm going to come in and we're going to go through all of this and work hard on these following questions. But the first question, every Social Security case I've ever done, I've done hearings in Charleston, West Virginia, I've been in Morgantown, I've been in Ohio, I've been in Erie, Seven Fields, Pittsburgh, Johnstown. First question's going to be, why is it that you can't work 8 hours a day, 5 days a week on a sustained basis? Now, there may be variations on that. Maybe, why can't you work? What keeps you from working? So while my staff comes and gets me at this point, I want you to write that question down, and I want you to think about that for a couple minutes, and we'll get started on that. I'm really looking forward to the next half hour with you so that we can work on this together, and I can answer any follow-up questions that you have, and know that you're going to be in best possible spot going forward. So I'll see you in a couple minutes. Thanks.